Okay.
I apologise for my tardiness and delay, but here we go.
Yeah, I should have fined you, but oh well. All right then.
Um,
Well, good morning, good evening to you, to the accredited practitioner and to the audience of the court. I have no announcements to make today, so if pursuant to the orders memo as issued on May 5th, 2021, the both parties have been allotted 30 minutes to speak for oral arguments. And the court will hear now be hearing oral arguments from Teal on behalf of ABISTAN.
Thank you, Mr. Arbiter. If you forgive my tardiness, I'm just getting my documents in order. Pardon me, I cannot find the guide for how to address the court. I request that it be sent to me again if that is.
You can begin with either good evening or good morning, depending on what time is for you, which I believe would be the evening, and then Mr. Chief Arbitrator, and may it please the court. That's how you would begin.
Thank you, Chief Arbitrator. Good evening, good morning. For my time zone, for my purpose, I shall be conducting this as if it were evening. So, good evening, court and Chief Arbitrator. I would like to begin by presenting the case for ABISTAN against the United Nations. However, I must make it noted that we, as ABISTAN, refer to the United Nations in a term which is regarded by the international community and not by ourselves, as we do not recognise not only the legitimacy but the existence of the United Nations. We bring this case to the Permanent Court of Arbitration as a petition review for the decision of not permitting ABISTAN to leave the United Nations. I'll begin my introduction by stating that the United Nations is only an organisation. It's an organisation which is not only composed of its members, it's legitimated by its members, but that's the extent of it. It cannot go any further. Its powers are completely arbitrary. They are only they're only to be used when permission is given by member states and accepted. So therefore, I would now like to begin by stating the nature of the underlying case as explained in the petition for review. So, ABISTAN, a sovereign nation, and according to us, the only sovereign nation, has announced its departure of the United Nations. However, we have been informed, our government, ABIGov, has been informed that we cannot leave the United Nations. The issues that we pray the court and new chief arbitrator review is whether, firstly, the United Nations Charter needs to provide for member states from leaving the United Nations. We argue that this is not necessary. Although it's not made in express terms, it's implied, and therefore that is sufficient enough. Secondly, whether the United Nations can prevent a member state from leaving the United Nations. We argue, as the aggrieved, no, it cannot. And thirdly, whether the United Nations has a treaty with ABISTAN. Our argument is that as we do not recognise the legitimacy or existence of the United Nations, we did not intend to create legal relations with them as to, go contradict ABISTAN's international policy or national policy. And we did not even request to enter. So therefore, the existence of ABISTAN within this United Nations is null and void. This happened on the 26th of April 2021, where ABISTAN announced that we had left the United Nations and were told 2 days later that this was not possible. We would like to bring forward not evidence of a manner which is cross-referenceable. It is instead a matter of constitutional and public interpretation. This means, as you are well aware, I'm sure, Chief Arbitrator, that you'll take the facts of the case, you'll take the existing law in the nature of the case, and you will apply the law and declare what the law is. We want to hear. We argue that it should not be heard from witnesses or subjective interpretation, but instead in your better judgment. The summary of the argument, as per ABISTAN, goes that the United Nations was responsible for determining that we could not leave the United Nations. Following this announcement, it is contrary to the precedent started, assuming we're going by common law, the precedent established in the reply from the Secretary General to the letter of the 20th of January 1965 from the First Deputy Prime Minister and Minister for Foreign Affairs of Indonesia. Now, Chief Arbitrator, I have sent you this in the petition for review. This evidence. It's a long-winded title, granted, but it's a title of a letter, an official correspondence between the United Nations Secretary General and a national authority of Indonesia. To give a bit of context to the court and for the benefit of the transcript, this was where Indonesia, the only nation or member state recorded to leave the United Nations of its own accord, has happened. So they did indeed leave the United Nations, although granted they did rejoin later. But that was again under the volition of a sovereign member state, or a sovereign state, as I should say. Additionally, the aggrieved, us, ABISTAN, claims that we have never entered a treaty and we never intended on joining the United Nations. Therefore, the Vienna Convention on the law of treaties need not apply, which would, hold that we hold a treaty with them. But even if, Chief Arbitrator, this did apply and we did have a legal treaty, under Article 62 of the Convention on the Law of Treaties, states that we only are strengthened in our argument to the court. And if there are no questions, I suppose, no cross-examination from my learned friend, who I do not see is present, or from the court itself on matters of clarification, then that rests our introductory speech. Thank you, Chief Arbitrator.
That's all from the aggrieved. I do have one question here, Mr. Teal. The question
Yes, Chief
is,
Arbitrator.
you are specifying, on behalf of the aggrieved, you are specifying that you are leaving. It is not the international community that you are leaving, or you're not trying to mistaken with leaving. However, what you are trying to clarify is that you are trying to leave the organization of the United Nations, the organization itself, that is.
Indeed, Chief Arbitrator, because we see the United Nations as maybe not a positive body, let alone an existing one. We believe the United Nations requires us to recognise the legitimacy and existence of other states and of other organisations. By no means do we wish to leave or exit existence or the international community, or still cooperate as far as needed with, Earth.
Very well then. If there's nothing further. I mean, there's nothing further from the court, neither from our friends at the defense, nor from the aggrieved yourselves. Very well. Um, Considering the fact that, well, from what I said before, the we will be hearing, well, we'll be deciding on the merits as well as the evidence and the arguments as presented by only the aggrieved, and what the aggrieved have to offer. Um, Therefore, we will be adjourned for this time being until the court shall decide on its opinion. If there
Thank you,
is
Chief Arbitrator.
if there's nothing else, nothing further to be motioned or to be said by the aggrieved, then please say so now. Very well then. Thank you for your time.
Thank you, Chief Arbitrator. Thank you.